I am opening the 91st session of this trial. Dr. Savatius, we have an application here by yourself, sir, about summoning additional witnesses, Mr. Tohar and Mr. Shimoni. I think we should consider this first off this morning. What can you say by way of explaining this
Herr
application,
Präsident, das
sir?
Beweisthema ist in dem Antrag angegeben.
Dr. Savatius, Your Honor, the subject of the proof is listed in the application.
Anträge bereits einmal zu Beginn des Verfahrens gestellt. In der 6. Sitzung vom 17.04.61 hat das Gericht den Antrag auf Vernehmung dieser Zeugen durch Beschluss abgelehnt, mit der Begründung, dass es unerheblich sei, auf welche Weise der Angeklagte nach Israel gebracht worden sei. Ich teile die Auffassung des Gerichts nicht, falls der Angeklagte im amtlichen Auftrag des Staates in Argentinien festgenommen und nach Israel gebracht worden ist. Die Auffassung des Gerichts wäre in einem zweiten Rechtszug nachprüfbar. Eine solche Nachprüfung kann aber nicht rein theoretisch erfolgen, sondern nur aufgrund nachgewiesener Tatsachen. Bei einer Beanstandung des Beschlusses vom 17.04.61 wird es sich um die Geltendmachung eines Verfahrensmangels handeln. Wenn dagegen die unter Beweis gestellten Tatsachen erwiesen sein sollten und wenn das Gericht dies als unbeachtlich erklären sollte, so liegt ein sachlicher Rechtsmangel vor. Für dessen Nachprüfung sind meines Erachtens andere Gesichtspunkte maßgebend als bei reinen Verfahrensmängeln. Und zum Nachweis dieser Tatsachen beantrage ich den Antrag auf Vernehmung der beiden Zeugen stattzugeben.
I submitted these two applications once before at the beginning of this trial. And in the 6th session, on the 17th of April 1961, the court rejected the application to hear these two witnesses by handing down a ruling about this. And the reasoning then was that the manner in which the accused had been brought to Israel was irrelevant to this trial. I do not share this conception in a case where the accused was detained in Argentina and brought here on behalf of the State of Israel in an official capacity. There should have been an additional examination of this, but this additional examination cannot be merely theoretical. It must base itself on the proven facts. And when an appeal is being lodged against the decision of the 17th of April 1961, the subject would be an omission in procedure. Whereas, on the other hand, if the facts are proven, the facts on which this contention is based, and if the court were to proclaim them as irrelevant, then we would have a substantial legal defect here, and with regard to such a defect, I believe other points of view would be applicable than in case of merely procedural omissions. And in order to prove that fact, I would like the court to respond to my request to hear these two witnesses. President of Court, Dr. Savatius, I'm not quite sure that I have understood your technical terms. They are taken from another field of procedure with which we are not familiar here, as familiar here. In any event, that decision which you have mentioned, sir, decision number 3, There we rejected the application to summon these witnesses because we said at the time that under law there is no significance attached to those facts which you, sir, wanted to prove through these two witnesses. To put it differently, if all you are asking, interpreter's correction, in other words, even if everything is correct which these two witnesses are required to prove, this still would not change anything. And from this point of view, nothing has changed. I actually regard your present application in the nature of an appeal against the previous application, and this is not possible in the same court which gave the previous ruling. What do you say to that, sir?
Herr Präsident, es ist keine Berufung gegen den ersten Beschluss, der unanfechtbar ist. Der erste Beschluss betrifft aber lediglich das Verfahren, nämlich ob das Gericht zuständig ist. Während der sachmaterielle Inhalt im Urteil entschieden werden muss, aufgrund von Tatsachen, die bisher nicht feststehen. Nur das wird in der Berufung anfechtbar sein, was nachgewiesen ist. Wenn also im Urteil festgestellt wird, tatsächlich lag ein amtlicher Auftrag vor, gleichwohl ist das Gericht zuständig, so kann das nachgeprüft werden. Wenn diese Tatsache aber nicht feststeht und nicht durch Zeugen nachgewiesen ist, dann kann die Berufungsinstanz nicht auf rein theoretische Überlegungen in eine Prüfung dieser Frage eintreten. Das ist meine Ansicht, die beruht auf der deutschen Rechtskonstruktion.
President of Court, I think that even in this case, other avenues will be open. Previous statement by Dr. Savatius. Your Honor, this is not an appeal against the previous decision. That is, of course, incontestable here. But I should like to explain. First of all, the witnesses were summoned then only in regard to the question of the competence of the court. But as for the substantive content of the matter, this should go into the judgment of this trial. And then, if an appeal is lodged, it can be based only on facts that were proved in this case. And if it is then found that this was proven and the court was competent in it, then only the proven facts can be discussed. And one can only base oneself on witnesses that have appeared here. This, at any rate, is the way it is in the German conception of law. President of Court, I think that if a court of appeal, in case of an appeal, finds that this testimony was relevant, that court will have ways of summoning the witnesses even in that later stage, in the stage of appeal.
Herr Präsident, ich bin über die Praxis des höheren Gerichts nicht unterrichtet. Wäre dankbar, wenn das Gericht eine Entscheidung fällen würde.
Dr. Savatius, Your Honor, I am not quite familiar with the procedure in higher courts. I would be grateful if Your Honors would make a ruling at this time.
Mr. Hausen, what could you say to this? If it please the court, this time as well the request of the counsel for defense is again trying to undermine the authority of this court. He wants to summon witnesses in order to be able to hear from them the claim that this court is not competent. This is what he writes himself. And this claim had already been examined, and the request for summoning the witnesses had been made already at the outset of this trial. And the counsel for defense pointed out that if it is proved that the emissaries of the state were actually responsible for the kidnapping of Eichmann, then the court's competence would be precluded and the court will have no right to try Eichmann. I don't have to reiterate what I previously stated, but may I point out in a nutshell that after all, the decision which had already been made is certainly valid for this stage of the trial. If I may reiterate what the President of Court said. After all, the decision which was taken is a decision which is binding, and it is absolutely impossible to re-examine the matter. It can only be done in the stage of the appeal, and therefore a decision had already been taken in regard to what the Council of Defense is now requesting, and all the arguments had already been clarified in this connection.
President of Court, if I understood Dr. Savatius correctly, the application now is to hear the testimony at this stage out of, as a precaution in case of an appeal later, that this would be on the record for such an appeal, if I interpret this correctly.
If this is the case, so I suppose the matter is quite clear. According to our procedure, the Court of Appeal is authorized to take evidence, and the Court of Appeal then can decide in whether it is significant to examine the ways in which the accused had been brought here. I claim that it is not important at all in which way the accused had been brought to this country, but this will certainly be incumbent upon the Court of Appeal to decide.
The presiding judge is now writing out the ruling which he will announce in a few moments about the application by defense counsel. President of Court, ruling number 94. The defense attorney requests that Mr. Tohar and Mr. Shimoni be summoned as witnesses, and that in order to confirm his argument that this court is not competent to deal with this case. This request differs in nothing from a previous application in the same matter, which we rejected in our ruling number 3. Therefore, we once again reject the present application as well. Now we've received another application for hearing a witness, also by Dr. Servatius. Did the Attorney General receive a copy of this application, and did you wish to respond to this request?
Yes, I have.
Well, we shall discuss this application now, then. It is an application to summon the lawyer von Taalingen. Dr. Servatius, would you like to explain your application?
Herr Präsident, es ist ein holländischer Rechtsanwalt, der Professor Meyers vertreten hat. Es ist dies der Professor Meyers von der Universität Leiden, dessen Auswanderung beantragt wurde und auch gegen Zahlung von 150.000 Schweizer Franken abgelehnt wurde mit der Begründung, er wäre Intellektueller, und der Angeklagte ist gerade zu diesem Punkt befragt worden. Nun schickt mir dieser Rechtsanwalt die Abschrift eines Schreibens vom 30. Mai 1961. Das ist ein Schreiben, das er hier an das Gericht gerichtet hatte in holländischer Sprache. In diesem Schreiben teilt er mit, er sei selbst in der Angelegenheit tätig gewesen, er sei in Berlin auf dem Amt 4b4 gewesen und habe dort mit dem Vertreter des Angeklagten, mit Günther, gesprochen, und es habe sich ergeben, dass Himmler sich diese Entscheidung selbst vorbehalten habe. Das deckt sich mit der Einlassung des Angeklagten. Ich bin der Ansicht, dass diese Aussage erheblich ist. Nun ist die Zeit so kurz, deswegen habe ich beantragt, sich mit einer eidlichen Erklärung zufrieden zu geben, die der Zeuge vor einem Notar in Holland abgeben soll. Ich habe ihm telegrafiert und ihn darum gebeten. Denn wegen dieser Sache ihn besonders jetzt noch kommen zu lassen, ist wohl ein zu großer Aufwand. Aber falls es nötig ist, müsste er erscheinen. Es ist deswegen von Bedeutung, weil es die generelle Linie des Angeklagten betrifft, der erklärt, ja, ich habe alle diese ablehnende Bescheide nur gegeben, weil sie von höchster Stelle angeordnet waren, und hier der Zeuge bestätigt es und hat sie aus freien Stücken gemeldet, als seinerzeitiger Vertreter eines Verfolgten. Ich habe eine Abschrift des holländischen Briefes gefertigt, ob sie ganz richtig ist. Ich habe es nach bestem Können gemacht.
Okay.
Ich nehme an, dass das Gericht diesen Brief nicht zur Kenntnis hat nehmen können, weil er in Holländisch war und dass er übersehen worden ist.
לא, זה לא כך. נעשה תרגום הולנדי,
A
ואז הוא
translation
עבר
into Dutch had been made, and only later on the original had been submitted to the Council for Defense.
המכתב ההולנדי אמנם היה בטיוטה, ולכן הוא עבר יחד עם המכתב.
It was in the form of a draft, and therefore it hadn't been conveyed together with a letter.
Dr. Savatius, Your Honor, this is a letter from a Dutch lawyer who had represented the Professor Meyers from Leiden University, in connection with whom documents were submitted here about the question of an application at that time for releasing him in exchange for 150,000 marks. This application was rejected at the time because he was an intellectual, and the accused was asked about that document here in court. I have a copy of a letter sent by this Dutch attorney to a court on the 30th of May 1961, and this attorney says that he himself had been active in this matter at the time. He went to Berlin at that time, visited 4B4, met the deputy of the accused, Günther, and there he was told that it was upon strict orders from Himmler that the application to release Meyers was rejected. Now, this is in accordance with the words of the accused in his testimony here, and that is important. Therefore, it is also relevant. There is, I think, no time to bring this Dutch lawyer to testify here. Therefore, I cabled to Holland and asked the man to submit an affidavit in front of a notary public in Holland. I didn't think it was important enough to summon him here, but if there is no other choice, maybe we shall have to bring him. But it would be quite an expense. The whole matter is important for proving a general contention of the accused, which was that he always acted upon orders from above. And this lawyer in Holland now voluntarily confirms this, and he, after all, is a man who at the time represented a persecuted person. I have a translation here. I hope it corresponds completely to the Dutch original. I'm afraid that the court had to ignore this earlier because it came in Dutch.
I should like to explain to the Council for Defense what I'm doing with these letters. The court and the President of the court and myself receive all sorts of various letters, and very often, as a result of ignorance of our procedure, we are approached with proposals to give evidence. I had always sifted these letters in accordance with their contents. Either these were letters for the defense or for the prosecution, and I either sent them to the prosecutor or the counsel for defense. I, according to the contents of the letter, found out that it actually belonged to the defense, and therefore I transmitted this letter to you. It took some time because we had to translate the document.
Ich habe eine Reihe solcher Weiterleitung durch das Gericht erhalten und wahrscheinlich dann auch dieses Schreiben. Es wird aber in der Menge von Korrespondenz, die jeden Tag eingeht, wird es untergegangen sein, dass man den holländischen Text überflogen hat und ihm die Bedeutung im Moment nicht beigemessen hat, die er tatsächlich hatte. Ich bitte daher, die Verspätung des Antrags zu entschuldigen.
Your Honor, I have indeed received from time to time letters which were conveyed through the court to the defense. But it is quite possible that in this mountain of documents and letters which have been arriving, this document, written in Dutch as it was not noticed at first sight, and we did not really grasp its basic significance, and therefore I would like to apologize for the late date at which I'm submitting this application.
Did you already receive a reply to your request addressed to the Dutch lawyer?
Ich habe erst gestern ein Schreiben dieses Anwalts mit der Abschrift bekommen und bin so erneut auf dieses Schreiben gestoßen. Ich habe ihm gestern telegrafiert und vielleicht, dass ich heute oder morgen eine Antwort bekomme.
Your Honor, only yesterday did I receive a letter from this attorney, which once again drew my attention to the whole matter, to that copy which I had previously but apparently forgot. Therefore, yesterday I cabled him, and I hope I shall have his reply today or tomorrow.
So that the counsel for defense doesn't know whether the Dutch lawyer is prepared to come here, or in general, what is the form in which he would like to give evidence?
That I do not know yet.
Yes, Mr. Hausner.
Mr. Hausner, by permission of court, I think it is premature to discuss it, therefore. If the defense wants to bring Mr. Van Taalingen-Dols as a defense witness, it is perfectly legitimate, and there could be no objection to this, that this man appear here and give his testimony from the witness box like anyone else. He certainly will receive an entry visa to Israel, and he can come and testify and speak his mind. I do not think that this is a case to which one could apply the procedure of affidavits, because here we have a man who has free movement. There is no danger for his coming here, and there may be use and purpose in hearing him. At any rate, if the defense attorney simply wants to prove from that testimony that this man was the representative of Professor Meyers and nothing else, and that in connection with the investigation concerning Professor Meyers, that man was referred as a lawyer to the department of the accused in Berlin, and that there he was told by Günther, I cannot deal with this, this is Himmler's decision. If that, and that alone is the purpose of this testimony, there will be no objection on my part to the admission of the letter in evidence. Yes, this letter. If that is all which ought to be proved through this letter, that in the course of dealing with this matter, the Dutch attorney was referred from Holland to Berlin, that he was taken to Department 4B4, that there Günther told him, this is a matter for Himmler to decide, then I have no objection to admit the letter.
There is
Judge Raffet.
another point. If you could see item B of this letter, I see it in accordance with the German translation. I understand that Dr. Servatius intends to prove item B and item C, and the question is whether you agree with this procedure.
Mr. Hausner, here he refers to a book, Your Honor. Certainly this cannot be proved by evidence here. He refers us to a book. I am speaking about what Mr. van Taalingen-Dols reports in the letter from his own knowledge. And what was it? He dealt with the Meyers affair. He was referred to for before. He traveled to Berlin, met Günther, and Günther told him, this matter of an exit permit for Meyers is Himmler's decision and his alone.
Perhaps there is a letter there. I see that he has on the 14th of July 1943, Himmler demanded recommendations in connection with the Meyer case.
If Your Honor will note, it says that this is taken from the above-mentioned book. That is to say, this is not from his own knowledge, but from a book. And that, of course, he cannot testify to.
Yes, this was a letter he wrote.
Mr. Hausner?
This is a book he wrote by himself, but this might be in accordance with some sort of hearsay evidence.
Mr. Hausner, that may be so.
There are 6 pages referring to Günther. Let me say this is rather comprehensive. What is the name? What is the number of our exhibit referring to the matter?
That was Judge Halevi. Now, Mr. Hausner, I think it is mentioned in the application itself. It says here that the documents are T34 and T526. But I believe that we submitted an entire series of documents about Professor Meyer, and we also submitted the final decision on that matter signed by the accused at that time.
Who signed it, the accused or Günther? I understand that the Counsel for Defense will agree to an affidavit. I think we shall ask for an affidavit at least, which will specify certain facts which refer to the accused, of course. It will also refer to Günther and will depict the whole situation.
Mr. Hausner, yes, Your Honor, but if as a result of the detailed affidavit and any new matter which we do not have here, if it then transpires that we have to examine the witness, then I shall insist that he be brought here and that I can cross-examine him.
You can, from the outset, already submit him questions, and submit him questions, and when we shall see what is going to happen.
Your Honor means in order to have him questioned in Holland?
The best thing at this stage would be the affidavit. It would be the most convenient thing, that he can, for instance, go to the office of the notary public and make a sworn declaration.
Your Honor, but it is not impossible that he would choose to come here and testify.
Yes, coming here would certainly involve considerable expenses, and I should like to have one point clarified. Up to one point you would like to go in order to save Dr. Servatius these expenses, which would most certainly crop up. Of course, he has a right to ask for his being questioned here.
Mr. Hausner, very well, sir. At this stage, I would then say, if all the defense wants to prove is confined to the fact that Günther told the lawyer that Professor Meyer's release depends on a decision by Himmler, then I would agree to have this submitted in evidence without questioning the witness. But to the extent that more is being intended here, then I would like to know what this additional proof is, and then I would make my decision.
Perhaps the most practicable way would be to secure from the Dutch lawyer an affidavit which is going to make at the office of the local notary public.
President of Court, Dr. Servatius, would you please try to obtain an affidavit from this witness as soon as possible? It is quite late at this stage, and according to that affidavit, we shall then see what the position of the Attorney General will be. He shall have the right reserved to request that the witness be then possibly brought here to be cross-examined.
Jawohl, ich bin damit einverstanden. Ich werde sofort mich nochmals mit dem Zeugen zur telegrafischen Verbindung setzen.
כן, אז הכוונה היא...
כן, אני מסכים, אני עוד אבוא ביד בדברים
Dr. Savatius, yes, Your Honor, thank you, I agree. I shall get in touch with this witness telegraphically once again immediately.
You will also clarify whether he's ready to come here, and this might affect the whole issue.
Previous statement by Dr. Savatius, especially I would like to find out whether he is prepared to come here. President of Court.
Reference is made here, of course, to an affidavit before a notary public, and in accordance with the procedure of the Dutch law, which I do not know, that there in this notarial statement, he will have to specify all the facts known to him.
Judge Rave, including the sources of his information.
Yes, of course, inclusive of the sources of the aforesaid information. And that he also attaches relevant documents if he has them in his possession.
Dr. Savatius, I shall take the appropriate steps.
I see, Mr. Harbutner, that you have submitted to us this time a series of documents, but this came with a considerable delay and we had no time to peruse them. You are certainly doing your best, I know.
Mr. Hausner, yes, this has been taken care of. I'm sure beginning this afternoon it will all be in the proper order.
To continue the cross-examination of the accused. I must recall to the accused that he is still testifying under oath. Yes, I'm fully aware of it.
Mr. Hausner, the accused, last Friday you said in your testimony that sometime after the outbreak of the Second World War, you traveled with Stahlecker to the occupied part of Poland, to the government general. When did you travel there?
Am Freitag sagten Sie in Ihrer Aussage, dass kurze Zeit nach Ausbruch des Zweiten Weltkrieges Sie mit Stahlecker in den eroberten Teil Polens fuhren, ins Generalgouvernement. Wann fuhren Sie?
Ich kann mich heute nicht mehr genau erinnern, wann das war, aber es war um jene Zeit zumindest, als der Teil, den man besuchte, kriegsfrei war. Und zwar bin ich ja bis zur russisch-deutschen Demarkationslinie gekommen, weil man einen Teil durch die sowjetisch besetzte Zone durchfahren musste. Und ich entsinne mich noch, dass ein Kommissar der damaligen GPU mit uns gefahren ist als Begleitung durch diese beiderseitige oder russische Zone. Ich kann mich da nicht mehr erinnern. Also das dient mir zum Nachweis der Zeit, wann es gewesen sein muss.
I cannot recall exactly the day. I can't say this with any degree of certitude, but it was at the time when the part which we visited was free of any war operations. I know that we passed the Russo-German demarcation line. I understand that we also passed through Soviet enclave, so to speak, because we are escorted by a GPU commissar, and this more or less proves, testifies to the period of.
How long did you stay in occupied Poland at that time?
Meines Erachtens war es nicht länger wie höchstens 2-3 Tage.
As far as I remember, it couldn't have been more than 2 or 3 days.
It was before the 17th of September 1939, which was the date on which the border was demarcated between the Reich and the Soviet Union.
Der Tag der Absteckung der Grenze zwischen dem eroberten Gebiet Deutschlands und der Sowjetunion war.
Ich glaube, dass es nach dem Tage gewesen sein muss, denn die Demarkationslinie war bereits ein fester Begriff gewesen und nur durch man musste, um einen bestimmten Weg fahren zu können, musste man ein Stück durch sowjetisch besetztes Gebiet fahren, und da begleitete ein Kommissar der sowjetischen Grenzwache diesen Wagen. Also es muss nach diesem Tag des Übereinkommens gewesen sein.
It seems to me that it was after that day of the 17th of September 1939, because the conception of demarcation line was definitely established at the time I visited the General Gouvernement, and we had to go together with the Soviet Commissar because we had to cross the Soviet enclave, but the matter of division was clearly established.
What was the route which you took
Das weiß ich
then?
nicht mehr. Es war jedenfalls der Distrikt Radom, Lublin, jedenfalls in dieser Gegend um den San herum.
I cannot recall exactly, but at any rate this was in the Radom area, the Lublin region, near the San River.
Ziemlich genau feststellen, weil es, glaube ich, nicht sehr viele Grenzübergangsstellen gab, die gemäß der sowjetisch-deutschen Vereinbarung zu befahren oder zu begehen waren.
At any rate, it will be very difficult to establish the route, because after all there were not many places where, in accordance with the Russo-German agreement, it was possible to cross the border.
I do not wish to establish anything. I want to hear from you. What cities did you pass? What places in occupied Poland did you visit?
Ich will nichts für die Zukunft feststellen. Ich will aus Ihrem Munde hören, an welchen Orten waren Sie und in welchen Städten waren Sie zu Besuch im eroberten Polen?
Auf jeden Fall kam ich auch nach Nisko am San. Das weiß ich genau.
At any rate, I went to Nisko on the San, this I remember clearly.
And you saw the tortures, the butchery, the slaughter committed by the German conquerors in the very first days of the occupation, didn't you?
Und die Morde, die die Deutschen an den Juden Polens schon in den ersten Tagen der Eroberung durchführten.
Ich sah weder Morde, ich sah weder Folterungen. Ich wusste um jene Zeit überhaupt nicht, dass derartiges passiert war, und ich kann es jetzt im Augenblick auch nicht einmal sagen, ob um diese Zeit dieses schon passiert gewesen ist. Um die Zeit, als ich dort gewesen bin, habe ich von dererlei Sachen nicht nur nichts gesehen, sondern auch nichts gehört.
אני רוצה להגיד מיד שאינני רוצה שום השתתפות
I
של
wish to
הקהל במשפט הזה.
stress that I do not want any audience participation in this trial. And if this is to happen, I shall take the sternest measures. And I do not wish to have to repeat this injunction.
At that time, I didn't see any trace of murder or persecutions. At that time, I didn't know that it was going on at all. And I don't know even if at that time these atrocities were already being perpetrated. I didn't see it anyway at that time.
We have heard a series of witnesses here testifying about what the conquering Germans perpetrated in the first days. Those people felt it on their flesh, and you didn't see any of it?
In den ersten Wochen, den ersten Tagen gemacht hatten. Sie hörten und sahen das, und Sie haben es nicht gesehen?
Wie sollte ich so etwas hören oder sehen, wenn ich in Berlin am Schreibtisch sitze und damit ursächlich gar nichts zu tun gehabt habe?
How could I possibly hear about it? How could I see it when I was sitting at my desk in my Berlin office and I have no contact whatsoever with what was going on at that time in the occupied Poland?
I'm asking about your trip from Berlin to Nisko, about your visit in the Lublin area, about the towns you went through in Silesia, Krasnowitz, Sosnowitz, Krakow. Did you see what was happening there or not?
In den polnischen Städten, in Lublin, in den schlesischen Städten, in Katowice, Sosnowiec, Krakow. Haben Sie dort nichts gesehen?
Dort habe ich nichts gesehen. Außerdem fanden diese Besuche nicht um jene Zeit statt, sondern später. Es ist natürlich klar, dass auf der Fahrt nach Lublin auch andere Städte berührt worden sind. Jedenfalls von dem, was Sie anschnitten, Herr Generalstaatsanwalt, haben ich weder gesehen noch gehört.
This journey was too late, therefore I couldn't see the atrocities perpetrated. Of course, I passed through other towns after my journey to Lublin, but I hadn't seen any trace of atrocities being perpetrated at that time.
You will agree with me that those who participated in the meeting on the 21st of September 1939 with Heydrich heard from him about the plan which already then was in Heydrich's mind, a plan for total extermination.
Am 21. September 39 bei Heydrich aus seinem Munde über den Plan hörten, der in seinem Geiste schon damals ein Plan zur völligen Vernichtung war.
Es ist die Besprechung, wo ich angeführt wurde, an der ich aber nicht teilnahm, weil ich nicht teilnehmen konnte, denn ich war weder Amtschef noch Einsatzgruppenchef.
I am not asking you about this now.
In this meeting, my name is mentioned, but I didn't participate in it because I was not head of the department nor head of an operational group, so I couldn't and had no right to attend the meeting.
Mr. Hausner, Your Honor, he does not reply to my questions. President of Court, what do you mean jumping up? What did you mean by that, Mr. Hausner? Mr. Hausner, I am asking you, was it clear to the participants of that meeting, was it clear to them that Heydrich brought along at that time a program of total extermination?
Sie werden darauf übergehen, wenn die Zeit dazu kommt. Ich frage eine klare Frage, ob es den Teilnehmern dieser Konferenz klar war, dass Heydrich damals einen Plan für die Endlösung brachte.
Ich habe nicht teilgenommen, ich kann darüber nichts Verbindliches sagen, aber ich kann das eine sagen, nachdem ich die Urkunde gelesen habe, dass ich nicht zweifle, dass das, was darin steht, richtig sein kann und richtig sein müsste, denn es